The modern family justice system battles an immense structural problem: the sheer friction of litigation. Court backlogs stretch for months, and the financial burden of legal fees rapidly depletes the very assets families are fighting to divide. To counter this, Part 1 of the Family Procedure Rules establishes the overriding objective: the court must deal with cases justly, expeditiously, and at a proportionate cost. Every subsequent rule and procedure is calibrated to achieve this single goal. Because court resources are severely strained, the modern family justice system treats active judicial intervention as the absolute last resort, rather than the default method for resolving financial disputes. This module points to Section 10 of the Children and Families Act 2014, introducing the mandatory jurisdictional gatekeeper, the Mediation Information and Assessment Meeting, or MIAM. Before filing, a mediator confidentially assesses the situation to determine if the dispute can be resolved outside a courtroom. Under Practice Direction 3A, the court defines specific claims as a relevant family application. Disputes over financial remedies fall squarely into this category, making the MIAM a strict prerequisite for separating couples seeking to divide their money and property. The MIAM operates as a statutory barricade. It is designed by the legislature to actively repel premature litigation and force parties to consider alternative dispute resolution before consuming judicial resources. When an applicant finally issues their claim, they must provide documented proof to the court that they attended a MIAM, or prove they have a valid reason for bypassing it. The court only allows exemptions based on a strict, exhaustive list. An applicant can bypass the MIAM with clear evidence of documented domestic abuse, if a party is bankrupt, or if the application requires acute urgency. The administrative consequence for ignoring this rule is immediate. Without a mediator's signature or a valid Form FM1 confirming an exemption, the court will outright reject the application to issue proceedings. Alongside the MIAM, parties must also comply with the Pre-Application Protocol, annexed to Practice Direction 9A. This governs the specific behaviors the court demands before proceedings are issued. This syllabus section highlights the professional code of conduct. The protocol demands voluntary, clear disclosure of material facts. Lawyers operate under a strict duty of full and frank disclosure, and failing to provide an accurate financial picture violates professional ethics and misleads the court. Furthermore, the protocol explicitly prohibits using a formal court application as a hostile first step in negotiations. Filing for court intervention is reserved only for when a settlement has no reasonable prospect of success. Before a judge sees a case file, the system's architecture has already forced both parties to attempt alternative resolution and initiate complete financial transparency. If pre-action negotiations fail and mediation proves unsuitable, the pre-action phase ends and formal Part 9 proceedings commence. The timeline officially triggers with Form A, submitted online to notify the court of an intention to proceed. This forces an immediate response. The court fixes a strict timetable, counting down to the first appointment. Before that arrives, parties must exchange Form E. Form E requires an unforgiving standard of precision. It imposes an absolute, ongoing duty to provide full, frank, and clear disclosure of all material facts, capital assets, income, and liabilities. To further narrow the issues, the parties must also collaborate on mandatory documentation: Form ES1, which provides a case summary and chronology, and Form ES2. Instead of filing separate, conflicting asset lists, the lawyers must work on a single joint schedule of assets and liabilities. The disclosure phase systematically weaponizes paperwork. It forces a complete, transparent financial reality check on both parties before any judicial time is spent analyzing their claims. The first appointment is strictly a case management hearing. It is designed to define the issues in dispute and establish the evidence required, not to serve as a forum for final judgment. At this hearing, the district judge actively manages the evidence. They determine exactly which questions in the financial questionnaires must be answered, and control the instruction of any expert witnesses, like pension actuaries or forensic accountants. This case management is governed by the FRC Efficiency Statement, highlighted here. It dictates the use of standardized ES1 and ES2 forms to prevent wasted time arguing over basic asset values. For parties who cooperate, the court offers an accelerated procedure. If both sides agree on the necessary directions and file documents, in advance, they can bypass physical attendance at the first appointment entirely, saving significant legal costs. To maintain strict policing over proportionality, the court requires parties to file a Form H before every single hearing. This document provides a running total of the legal costs incurred by each side up to that exact date. The first appointment exists to organize the procedural battlefield and control the bleed of legal fees, setting exact parameters for the negotiations that follow. Following case management, the procedural timeline arrives at its centerpiece, the Financial Dispute Resolution Appointment, or FDR. The FDR is a unique judicial mechanism. It is a formal court hearing, but it is dedicated entirely to negotiation and settlement. The parties are expected to use their best endeavors to reach an agreement on the matters in issue. To facilitate open, productive discussion, the rules dictate that all offers and settlement proposals must be filed with the court at least 7 days prior to the appointment. Because the FDR is conducted on a strictly privileged basis, parties can negotiate without fear that their offers will be held against them later. Consequently, the judge presiding over the FDR is legally disqualified from having any further involvement in the case if it proceeds to trial. As listed here, the ideal outcome of the FDR is a consent order. When the parties reach a voluntary agreement on the terms of settlement, they draft this legally binding order for the judge to approve. The FDR acts as the court's ultimate engineered pressure cooker. It forces the parties to confront the reality of their financial situation and resolves the vast majority of cases before they require a costly final adjudication. When the pressure of the FDR fails to produce a settlement, the case exhausts all alternative routes and moves to the final hearing. Reaching this stage requires immense, costly preparation. The parties must adhere to strict trial bundle requirements under Practice Direction 27A, meticulously organizing every piece of evidence, chronology, and expert report for the judge to review. Within the context of the family justice system, the final hearing is not the intended goal. It represents the failure state of the Part 9 architecture. This brings us back to the overriding objective of FPR Part 1. The court's mandate is to deal with cases justly, expeditiously, and fairly, while allocating an appropriate share of the court's limited resources. This filtering mechanism, starting with the forced mediation at the MIAM gatekeeper, directly serves that objective. It saves expense by diverting disputes away from the courtroom at the earliest possible stage. The mandated financial transparency of Form E and the privileged, negotiation-focused space of the FDR ensure that when costs are incurred, they remain proportionate to the complexity of the assets. Ultimately, Part 9 operates as a precise behavioral engineering tool. It structures the timeline, controls the evidence, and applies targeted pressure to ensure that full litigation remains a rare exception rather than the default pathway for family practitioners.